So I have fielded quite a few emails and messages and figured I'd just put this in a video on why the judge on the New Jersey concealed carry case spent a couple dozen pages on carrying in areas open to the public. And all the gun rights organizations are putting out a summary, and instead of just saying, allowed to open places accessible to the public, and they're now putting in there partial. Well, the reason is the judge went through a couple dozen pages of analysis over what constitutes area open to the public, both on public and private lands. Now, I'm not going to get into curtilage around one's home and the definition of trespass under many state laws like the judge did, but basically what the judge is saying is if there is a general right to be there, like a shopping mall, public area of a doctor's office or medical building or somewhere else, that's a place open to the public. Said the same thing about a public library, places like that. State parks, things like that. They're open to the public. The public can walk in and walk out, and you don't have any fear that someone's going to say, hey, you shouldn't be here. Now, the difference is on private property. Now, there are areas of private property, and there's a whole body of law on the public areas of private property, the sidewalk in front of a building, the general reception area, the hallways leading up to, in and out of other offices. Those are usually basically public areas. But the judge did make sure to include the fact that areas where there's implied invitation for you to enter into that area, that would also be covered. Now, just to give probably a poor but an example, but one you might remember is, okay, think about a doctor's office. You can walk into a doctor's office reception area and ask a question. Hey, is this doctor have open appointments? And I want to hire him as my new doctor. That's a public area, open for the public generally to enter that area. But the exam rooms are an area where the public can go, but only once they're invited there. So once somebody comes out and says, doctor's ready to see you, come back to examination room number 4. Well, that's an invitation for you to enter that private area. The judge also went into an analysis of the curtilage around someone's home. So people are like, well, someone has private property. Can I just walk on their property? That's private property. It's not generally open to the public. And the judge did explain how walking up somebody's sidewalk, walking up the front driveway or walkway to knock on a door is generally considered open to the public unless and until the right to be there has been revoked, where somebody then trespasses you from the property. Remember, you can be trespassed from a place that's open to the public, and trespass doesn't happen until you've been notified or warned that you shouldn't be on that property. So the judge even talked about, having no trespass sign. So if you see a no trespass sign, for now, I would just stay off the property. If you knock on somebody's door and they're like, hey, no solicitations, I don't want you here, leave my property, I would leave the property. Anywhere else you can walk, whether it's a private business or a public building where you can walk into and no one's going to say, hey, Joe Public, you shouldn't be in this spot, you need to leave, you're generally covered under the judge's analysis. Keeping in mind all those exceptions, certain courthouses, post offices, schools, and things of that nature, where they are specifically enumerated. I get it. The issue people are having are areas that are not specifically enumerated. Can we walk in this portion of the store or that? So, that's the best way I can put it. Sorry I couldn't give any more, a clear definition of what's covered or what's not, but there's entire bodies of law and litigation pending all the time as to what constitutes a place open to the public, what constitutes the curtilage around your home, what constitutes, an implied invitation to enter onto private property, because there's different contexts on which a person may believe they're allowed to be on a property, depending on whether it's a just general member of the public, whether it's, the gas meter guy who's got to walk around your house to get a gas meter reading. There's different contexts in which these laws and basic rules are analyzed, and that's what the judge was trying to do there. I think she muddied the water too much. She could have just left it, you're allowed to open in public unless you, in any area you're able to go unless you're trespassed, but, judges will be judges, and, she's actually right. There's a huge body of law and a lot of disputes as to what context you would be an invitee or an area is open to you as a general member of the public. And unfortunately, she had to deal with it in the motion. And more unfortunately, it will probably be an area where there will be litigation and people will get tripped up. So just, be cautious. I know there are contradictions in the rules where she says you can go into the doctor's offices and medical facilities. Okay, but you may not be able to go right past the desk clerk and say, I know I'm not a patient, but I'm going to exam room 3 because the judge says I could be in a medical building. Well, you don't have an implied invitation to go beyond the receptionist desk, so that would probably be an area where you could get prosecuted. So again, there's a lot of contradictions, and unlike other rights where you're pretty clear on what your rights are, and where you can exercise them, unfortunately, this is the nature of living in a state that absolutely abhors and has no interest in acknowledging the exercise of your basic constitutional rights.